stipulation?
I never went around measuring my height.
That wasn't my question, Mr. Perry. Your Honor, may I retrieve the stipulation? The parties stipulate to the following facts. On October 8, 1990, Kenneth Perry represented that he was 5'9", 230 pounds, and residing at 7047 Swift Street in Lithonia, Georgia. Is that your signature, Mr. Perry?
Yes, that's my signature.
Thank you.
Ms. Hunt, you can put it before.
Yes, Your Honor. And you've represented your height at 5'10" before, correct?
No,
You never indicated that your height is 5'10".
not that I recall.
Did you not just say on direct testimony, speaking to your attorney, 5'10", 5'11"?
I was talking to Mr. Queen.
But you've never told me you were 5'10", is that what you're saying?
No, I haven't.
But you told Mr. Queen you were 5'10".
5'10", 5'11".
Now, men don't usually lie about their height to make themselves shorter, do they, Mr. Perry?
I wouldn't know.
And in 1990, you were 230 pounds.
My weight fluctuated.
You're a bigger guy, correct?
I don't know what you mean by that.
Well, how would you describe your size back in 1990?
In 1990, on my birthday, I was 208 pounds.
So you went from 280 pounds in July to 230 pounds in October?
I was 208 pounds.
8. And 230 in October.
Correct.
And that would make you a bigger guy, correct?
But I gained a few pounds since my birthday up until the day I was arrested.
You weren't a skinny man. Can we agree to that, Mr. Perry?
Yeah, I was chunky.
And your hair was cut closer on the sides, correct?
My hair was growing back out.
So it was even closer before.
Yeah, I used to wear brush waves.
And it was flat on the top and had a little bit of length on the top, correct?
No, brush waves, I had waves all around my head. When my hair grew out.
And you admitted that you did go to the victim's apartment the night that they were murdered, correct?
I was there that night.
And you have to admit that because your fingerprints were found on a plate in the house, right?
No, I have to admit that because it's the truth.
Because they were on a downstairs bathroom doorknob at the apartment, correct?
That is the truth.
This is a doorknob that John also touched, correct? Did you hear that testimony?
Oh yeah, I did hear that.
And a plate that John also touched, correct?
I heard that as well.
Now, you've heard that Pamela Sumter was 43 years old at this time, correct?
I believe they might have said her age.
And she was living with her brother in that apartment, correct?
Correct.
Pamela had only lived in Georgia for 3 months at this point, correct?
I wouldn't know that.
Have you heard that testimony
I don't believe I heard the 3-month part.
from her mother and her brother? Were you not listening to her mother and her brother's testimony?
Yes, I was listening.
And were you listening when everyone who testified indicated they never saw Pamela with a man? Were you listening to that part?
I heard that part.
Were you listening when Pamela Sumter told the detective she'd been celibate for years?
I heard that part, but I didn't hear anybody say they followed around to see if it was true.
And this is the woman that you claim sexually assaulted you while you were drugged in her bedroom.
That is the truth.
You heard Dr. Doss's testimony about the vaginal tears that Pamela suffered, correct?
Yes,
The abrasions that she suffered, correct?
yes,
How these kinds of injuries are most commonly seen in childbirth, correct?
correct.
How do you explain those injuries?
Well, I can't because I didn't rape her.
And who did, Mr. Perry?
Well, based on her statement, it was Alvin, the person that she had seen multiple times.
So your testimony is now that Alvin, who was having sex with John, raped Pamela.
I never said he was having sex with John.
Did you not say they were giving each other oral sex, Mr. Perry?
That's what I said.
Is oral sex not sex?
Or you said sex.
So he was having sex with John, correct?
John was giving oral sex.
So your testimony now is that Alvin raped Pamela, this person who was having sex with John.
Not that, I don't know because I wasn't there.
But it's your DNA and Pamela Sumter's vaginal swab, right?
Yes,
There's no one else's DNA, correct?
maybe he didn't ejaculate.
So you heard Ms. Sumter's interview with the detective about how insistent her attacker was, correct?
Correct,
They even went to the trouble of getting a Vaseline jar, correct?
correct.
So you're saying this person who was so insistent on raping Pamela, they didn't ejaculate?
I don't know what to tell you, I wasn't there.
So this real rapist, this person Alvin, he was also in his 20s?
You know, he was about 33. I have older brothers, so I had a pretty decent age.
And he was also dark-skinned,
He was darker than I was.
but he was significantly tall, correct?
Excuse me?
He was significantly taller than you,
Yeah,
correct?
he's a little taller than I was.
He's not 5'7" or 5'8", correct? Was Alvin also from Detroit?
He could have been.
Was Alvin also living in Lithonia?
That I don't know.
Was the mother of Alvin's children also a 9-minute walk from where the car was abandoned?
That I couldn't tell you.
Less than half a mile? Is that correct?
I couldn't tell you that.
But it is for you, correct?
I couldn't tell you that either.
Well, did you hear the testimony?
Yeah, but I wasn't living there at the time.
Do you dispute that the car was located less than half a mile from where Lisa Reed was living?
That's what the detective said.
The address that you provided to the courts is your address?
That's what the detective said.
Now, Mr. Perry, you weren't working back then, correct?
I was working at day labor places.
You didn't get a regular check, correct?
No, not at that time.
And that's why you had this little ploy, right?
Excuse me.
With the gay men. This is why you let gay men pick you up, right?
It is something you know to be true.
I'm asking you, Mr. Perry.
I told you never.
This is why you would steal from them, correct?
I never stolen anything from anybody.
Except sex from Pamela Sumter.
know, Ms. Hodder, I tell you, like I said before, my hands are clean. I did not rape Pamela. I did not kill Pamela or John. Now, did you hear me the first time when I said that, Ms. Hodder?
I did, Mr. Perry.
Okay.
And you can say it as many times as you want, but it doesn't make it true.
The truth never changes.
That's right, Mr. Perry.
And you know what, Ms. Hodder? I am a man of God. I am a true prophet of God. This day was the divine appointment. God showed me some things about you I would love to tell you if you want to hear them, because I know why you became a prosecutor.
Mr. Perry, this case is about you.
And it's
And
about
we're here
you
to
too.
talk about you, Mr. Perry.
And you're right.
Mr. Perry,
Yes, ma'am.
answer the question.
Yes, ma'am. Sorry, y'all.
Nothing else at this time, Your Honor.
Any redirect?
Just briefly, Judge. So, Mr. Perry,
Yes, sir.
you've heard the testimony and you've heard the evidence. Did you kill those people?
No, sir, I did not. I did not kill John, Pamela Sumter. I did not rape Pamela Sumter.
Nothing further.
You would say that. Oh, you're next.
Your Honor, this time defense rests.
Okay. The lawyers would approach. Ladies and gentlemen of the jury, it is 4:30, so I am going to release you for the day. Do not discuss this case amongst yourselves or with anyone, and I will see you in the morning at 9 a.m. Okay, you all want to place that on the record?
Your Honor, we do not have, any rebuttal.
You do not?
We do not.
Okay. So, in the morning, we can go ahead and do the charge conference now, and in the morning when we come back, we'll start closing arguments at 9 a.m. Are you all ready to proceed with the charge conference?
Yes, Your Honor.
Does everybody have a copy? I still need it. Okay, so we'll start with the state's request to charge. So with the state's request to charge, number 1, indictment, accusation, I will give. State's request to charge number 2, issue a plea of not guilty, I will give. State's request to charge number 3, presumption of innocence, burden of proof, reasonable doubt, I will give. State's request to charge number 4, jury, judges of law and facts, I will give. State's request to charge number 5, evidence generally, I will give. State's request to charge number 6, stipulations, I will give. State's request to charge number 7, judicial notice.
Withdrawn, Your Honor.
State's request to charge number 8, direct and circumstantial evidence. Mr. Queen, do you want the long version or short version?
Long.
Okay, so I will give the long version of direct and circumstantial evidence. State's request to charge number 9, credibility of witnesses, I will give. State's request to charge number 10, expert witnesses, I will give. State's request to charge number 11, witness attacked. How are you specifically asking that be read?
I'll withdraw that one, Your Honor.
And State's request to charge number 12, witness impeached. How are you requesting that be read?
The first, Your Honor, first thing.
So if you object,
Okay, so the state is requesting to impeach a witness is to show that a witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified.
there's been no impeachment.
I would disagree, Your Honor.
Which facts have been disproven?
Mr. Perry indicated that he didn't live at the address, even though he gave it to the courts as where he was residing. He testified that he never represented being 5'9", even though he signed a stipulation saying that he represented himself being 5'9".
Okay, so for, state's request to charge number 12, witness impeached, I will give the charge, the second line, which will state, the credibility of a witness may be attacked by disproving the facts to which the witness testified. Okay, state's request to charge number 13, prior statements. I will give state's request to
Being
charge.
judge, you object?
Your Honor, we had a number of statements that were admitted and read in totality.
I'll give state's request to charge number 13, state's request to charge number 14, single witness corroboration. I will give state's request to charge number 15, defendant's choice not to testify.
I'll withdraw, Your Honor.
State's request to charge number 16, identification reliability. I will give state's request to charge number 17, identification, burden of proof. I will give state's request to charge number 18, fingerprints. I will give state's request to charge number 19, DNA. I will give state's request to charge number 20, definition of a crime. I give state's request to charge number 21, multiple ways of committing a crime. I'll give state's request to charge number 22, intent. I will give state's request to charge number 23, no presumption of criminal intent. I will give state's request to charge number 24, presumptions and inferences. I will give state's request to charge number 25, venue generally. I will give state's request to charge number 26, verdict generally. I will give state's request to charge number 27, court has no interest in the case. I'll give State's request to charge number 28, sympathy, I will give. State's request to charge number 29, sentencing responsibility for, I will give. State's request to charge number 30, deliberations, I will give. State's request to charge number 31, unanimous verdict, I will give. State's request to charge number 32, malice murder, I will give. State's request to charge number 33, motive, I'll give. State's request to charge number 34, felony murder, I will give. State's request to charge number 35, causation and felony murder, I will give. State's request to charge number 36, aggravated assault with an offensive weapon. How do you want this to read?
I've scratched out with a deadly weapon, we charged it as offensive weapon. And then as to the second parenthetical, I think it could be either, Your Honor, so attempted to cause a violent injury to the person and or committed an act that placed the person in reasonable apprehension or fear of receiving a violent injury.
Okay. I will give it and add the and or in between the parenthetical. State's
Judge,
request.
it looks like it's charged as likely to result in serious bodily injury. That's the charge. That's the way in which it's charged in the case.
That doesn't dictate the parenthetical there, Your Honor. You can still commit the act of aggravated assault by either causing the person to be in fear or by attempting to cause the injury.
Okay, so as to State's request to charge number 36, aggravated assault with an offensive weapon, I will read it as follows. For aggravated assault, the state must prove that the defendant assaulted another person with an offensive weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person and or committed an act that placed the person in reasonable apprehension of fear, in apprehension or fear of immediately receiving a violent injury. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone.
Judge, for the record, then we object to the second parenthetical, committed an act, Because the way in which the indictment charge is attempted to cause a violent injury.
An indictment never alleges that they placed a victim in apprehension.
It's happened, just this one doesn't.
Okay, well, I'm gonna read it as I stated previously. State's request to charge number 37, determining if a weapon is offensive. I will give. State's request to charge number 38, aggravated battery. I will give. How are you requesting that that be read?
We charged it in two different ways, Your Honor. One was for disfiguring, and the other was for rendering useless. So not the first parenthetical, but the second and third would apply.
For aggravated battery, the state must prove that the defendant maliciously caused bodily harm to another person by rendering a part of that person's body useless and or by seriously disfiguring a part of that person's body. Okay, I'll give it as I just read. State's request to charge number 39, rape, I will give. State's request to charge number 40, possession of a knife during the commission of a felony. I will give State's request to charge number 41, theft by taking. I will give State's request to charge number 42, theft value over $500. I will give. Now, defendant's request to charge. Defendant's request to charge number 1, presumption of innocence, burden of proof, reasonable doubt. I'm giving. State's request to charge number, defendant's request to charge number 2, greater suspicion. I will give. Defendant's request to charge number 3, jury, judges of law and facts. I'm giving. Defendant's request to charge number 4, evidence generally. I'm giving. Defendant's request to charge number 5, direct and circumstantial evidence, the long version. I'm giving. Defendant's request to charge number 6, credibility of witness. I'm giving. Defendant's request to charge number 7, expert witness. I'm giving. Defendant's request to charge number 8. Are you withdrawing that, Mr. Queen?
I'm withdrawing, Judge, but you said you're gonna get it for the state, so
I went through it.
looking at the note, so it's
Right.
withdrawn for both.
I said the state withdrew it, and so.
Okay, so it's withdrawn for both, Judge.
Okay. Defendant's request to charge number 9, statement of defendant.
Withdrawn.
Okay. Defendant's request to charge number 10, voluntariness defined.
Withdrawn.
Defendant's request to charge number 11, circumstances of the statement's illegal detention.
Withdrawn.
Defendant's request to charge number 12, burden of proof as to voluntariness.
Withdrawn.
Defendant's request to charge number 13, constitutional rights.
Withdrawn.
Defendant's request to charge number 14, burden of proof as to rights.
Withdrawn.
Defendant's request to charge number 15, conditions precedent to consideration of statement.
Withdrawn.
Defendant's request to charge number 16, identification reliability. I'm giving. Defendant's request to charge number 17, identification burden of proof. I'm giving. Defendant's request to charge number 18, fingerprints. I'm giving. Defendant's request to charge number 19, DNA. I'm giving. Defendant's request to charge number 20, good character of the defendant. I will give. Defendant's request to charge number 21, mere presence, guilt by. I am giving. And I believe those are all of your charges. Is that correct, Mr. Queen?
That's correct, Judge.
Okay, I will see you all at 9 a.m. ready for closing. So, Ms. Potter, Mr. Queen, if you all want to get here early to test out the equipment, to make sure that it's ready to go.
Yes, Your Honor.
Or you can stay and do that now. So we're in recess.